Assalamualaikum warahmatullahi wabarakatuh. My name is Nina Safwani binti Muhammad Zaki. My matrix number is 067948. Today, our group will answer questions that are related to Hire Purchase Law and Law of Contract. The Hire Purchase Act of 1967, the HP Act, covers the hire purchase in Malaysia. The Hire Purchase Agreement, based on common law, is a contract in which the owner hires out objects and say that when the requisite payments are paid. The choice is up to the hire whether to carry through with the purchase of the items or to cancel the agreements and return the products. In other words, at the end of the hire time, the hire is offered the option to purchase. They may choose to reject this choice. Furthermore, under any purchase arrangement, the hire cannot sell the commodities while they are still hired out. This is because the hire does not own the merchandise. The Contracts Act of 1950 codifies Malaysian contract law and describes the steps necessary in creating a contract as well as the standard that decide whether it can be enforced. A contract is an agreement between two parties and impose legal obligation on both sides. For the agreement to be a valid offer and acceptance, suitable consideration, capacity and legality, mutual assent state that acceptable consideration, adequate consideration and capacity are the essential requirements. When one party's promise leads to the creation of a duty between the parties, contracts are formed. To be considered a contract, a promise must be given in exchange for sufficient consideration. The benefit treatment theory and bargaining theory of the consideration are two distinct definitions of the concept.
My name is Dayang Nur Syukriya binti Awang Sari and my matric number is 067895. Hire purchase is a legal arrangement whereby the owner rents out the products and agrees that the hire may either choose to keep the things or return them and end the contract. The Hire Purchase Act of 1967 defined hire purchase agreement as anything that includes a laying of goods with an option to purchase and an agreement for the purchase of goods by installment. Dora is known as the hirer in this hire-buy deal since she purchased the car from the owner. The first one is the right. Dora is known as the hirer in this hire-buy deal since she purchased the car from the owner. The first one is the right to request a copy of the agreement, Section 9. Dora has the right to seek a copy of the hire purchase agreement, enabling her to thoroughly analyze and comprehend the transaction's terms and conditions, including the total amount payable, the repayment plan or overdue installment. Dora also possesses right about the appropriation of the payments she makes towards the agreement, Section 10. Dora has the authority to choose how her money should be distributed across the various components of the agreement. Based on her priorities and financial capacities, she has the right to propose allocating RM600 to the car agreement and RM300 to the motorcycle agreement. In accordance with Section 11, Dora also has the option to request a magistrate's order for the removal of goods to a different location. Dora is allowed to ask a magistrate for permission to move the items covered by her hire purchase agreement to another location. If accepted, this enables Dora to transfer the products to a new place in light of legitimate factors and situation. Other than that, Dora is allowed to transfer her rights, interests, and obligations under the hire purchase contract to another party in accordance with Section 12. Dora has the right to transfer her authority as the hire to another person or entity by using this right. Hire purchase agreements rights titles and interests of Dora's company are assumed by the appointed liquidator. During the company's insolvency, this clause guarantees consistency and responsibility in the hire purchase agreement. In addition, under Section 14 of the Hire Purchase Act, Dora has the ability to buy the items covered by the hire purchase agreement before the due date. This indicates that Dora has the right to end the arrangement earlier than was initially intended. And last, under Section 15 of the Hire Purchase Act, Dora has the right to renegotiate the terms of the contract by returning the products to the seller. With this, Dora is able to cancel the hire purchase contract before it runs out. Dora released the condition of the contract and released from any additional financial commitments by returning the goods.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Hasiza binti Sukri. My metric number is 067887. Now, I will explain the question 2B, Law of Contract. A contract is an agreement that can determine the rights and responsibilities that can be applied to two or more parties who have reached an understanding. Among the examples of contracts include promises to deliver goods, services, and money. A contract law is crucial in governing agreements and responsibilities between parties. It offers an easy-to-use procedure for people to make a secure deal legal, guarantee fairness and predictability. Offer is one of the elements of the contract. An offer is usually a statement made by entity to a person offer for the purpose of partner's business. An offer must be made and delivered in a way that a reasonable person will assume will lead to a binding contract that can be enforced in court. According to Section 2A of Contract Act 1950, a proposal is when a person conveys to another person his readiness to conduce an act or refrain from acting in order to acquire approval of that other person. Upon receiving which is granted, a contract is made. In accordance with Section 2B of Act, a proposal is deemed accepted when the party making the offer express his approval. Upon acceptance, the proposal transformed into a promise. A promise was created when one of these offers was accepted. Applying to the current cases, in a newspaper advertisement, Mila promised an 2,000 reward for finding her lost handbag. The handbag was found by Zila, who recognized it as Mila's and gave it back to her. Here, the crucial legal presumption is that offer must be made and accepted in order there to be a legally binding contract. A public offer may be made under Malaysia's Contract Act 1950. For example, through newspaper advertisement, Zila effectively accepted the offer and performed the required act to obtain the incentive when she found that the handbag and gave it back to Mila. Next, before giving Mila her handbag back, Zila had discovered it without being aware of the rewards advertisement. Mila, though, resisted giving Zila the reward. Malaysian law presumes that social and domestic agreements are not meant to establish legal connection. It may be argued that provision of the price in this case was the result of the social or domestic agreement. Mila can argue that the offer of the award was only a show of gratitude and not meant to form a legally enforceable contract. Applying the mentioned rules, Zila is not qualified to receive the award because she was unaware of it prior to giving Mila her handbag back. Mila is not obligated to award Zila as a result. In conclusion, Zila is unable to claim the reward because she is unaware of the advertisement. Otherwise, she will be less familiar with the advertisement.
In conclusion, hire purchase law related to question 1, which is, in this question, Dora, as a hire under the Hire Purchase Act 1967, has several statutory rights to protect her interests and ensure fairness in the hire purchase agreement. These rights include the right to request a copy of the agreement, the right to appropriate payments, and right to request a magistrate order for the removal of goods, the right to transfer rights and obligation to another party, the right to have the hire purchase agreement's right assumed by a liquidator in case of liquidation, the right to buy the items before the due date, and the right to renegotiate the contract of returning the goods. The right to buy the items before the due and the right to renegotiate the contract by returning the goods. Other than that, we also can conclude that the law of contract is related to question 2. Based on this question, in the case of Zila and Mila, Zila may have a valid claim for the reward of 2,000 promised by Mila. By accepting Mila offers through her action of finding and returning the lost handbag, Zila fulfilled the requirements for the formation of a legally binding contract. However, Mila may argue that the offer of the reward was merely show of gratitude and not intended to create a legally enforceable agreement. The determination of whether the contract exists and Zila is entitled to the reward will depend on the court's interpretation and of the intention behind the offer and the surrounding circumstances. That's all from me. Thank you.